Hello, everyone, and welcome to Uncivil Law, where we learn through others' misfortunes. To increase your legal knowledge, please hit the subscribe button. For today's case, we're dealing with an assault on an airplane. This is the case of United States of America versus Monique Lozoya. In this case, there was an assault in the air, and there was a trial relating to this. And the question is, where does the trial happen? Because when you're in the air, where exactly did the assault take place? But fortunately, there's some federal law around this to help solve this problem, so let's get started with that. On July 19th, 2015, Lozoya and her boyfriend were flying home to California from Minneapolis. Their Delta Airlines flights to Los Angeles was scheduled for about 3.5 hours, the route taking them over Minnesota, Iowa, Nebraska, Colorado, Utah, Arizona, Nevada, and finally California. Lozoya wanted to sleep, but claimed the passenger behind her, Oded Wolf, began jabbing at his touchscreen monitor attached to the back of her seat. Each jab startled her awake, so we've got air rage going on here. So this woman wants to sleep, and the guy behind her is trying to interface with the touchscreen, and apparently it's causing some problems. In the middle of the flight, Lozoya estimated an hour before landing, her boyfriend about 2 hours, a flight attendant 90 minutes. Lozoya turned to Wolf, who had just returned from the bathroom, and asked him to stop banging on her seat. An argument ensued, and Lozoya slapped Wolf in the face. Wolf reported the incident to the FBI, who issued Lozoya a notice for charging her with a misdemeanor assault within the special aircraft jurisdiction of the United States. So we've got not the first and not the last incident of air rage. We've got one passenger who wants to sleep, another passenger wants to play with the thing. And when she comes back from the bathroom, she says, "Can you stop?" And I don't know exactly how she said it, but either way, an argument ensued, and then it ended with her slapping him. And then he said, "I'm going to report you to the FBI because it's a federal airplane." And now the FBI has to investigate this slap. Why can she slap? Well, it turns out that she can't slap. It's actually against the law. But the question is, where should the trial be? Lozoya's bench trial took place in the flight's landing district, which was the Central District of California. After the government rested, Lozoya moved for acquittal, claiming the government had not established venue in the Central District. The magistrate judge presiding over the trial denied the motion and ruled the venue was proper because the flight came to an end in the Central District. Lozoya was convicted and sentenced to pay a fine of $750. For assaulting another passenger on an airplane, she got off kind of light, all things considered. I wonder if she thinks this was worth it in the end. She then appealed to the district court, again arguing venue was improper. The district court found venue was proper because the plane had landed there and affirmed the conviction. A divided 3-judge panel of our court, however, agreed with Lozoya that the venue was improper and reversed conviction on this ground. So the Court of Appeals in a 3-judge panel said, no, you can't have the trial here. And then we're going on bonk, baby. We're going to ask the entire Ninth Circuit, what did they think? Is this a proper venue or not? So what is the law as it relates to assaults in the air? The assault took place on a commercial flight in the special aircraft jurisdiction of the United States. Decades ago, at the onset of the age of the jet aircraft, Congress recognized that crimes committed in the skies raised difficult questions. Although state criminal statutes generally cover crimes committed on board aircraft and flights over the state, the advent of high-speed, high-altitude flights of modern jet aircraft has complicated the problem of establishing venue for the purposes of the prosecution. In some recent instances, serious offenses have gone unpunished because it was impossible to establish with a reasonable degree of accuracy the state over which it occurred. And this was a report written in 1961, so the problem has not ameliorated since then. Congress chose to federalize certain offenses committed on airplanes, including murder, sexual assault, and this particular crime, simple assault. So in 1961, Congress recognized that planes move. And because planes move, it's a little bit difficult to figure out exactly where it occurred. And states have jurisdiction over these kinds of crimes. And then you want to figure out, well, what state it occurred in. And the problem is, well, how do you determine that accurately? And we don't know, with any degree of precision. So the federal government said, okay, well, the states still have jurisdiction, but we're also going to give federal jurisdiction. This is a federal thing. It's moving in interstate commerce. So we can define the rules as it relates to this article of interstate commerce, and we're going to give ourselves jurisdiction on the air in addition to whatever else anyone else has. So this isn't necessarily exclusive, but it is a way for the federal government to solve this problem. Lozoya contends the venue is proper only in the federal district over which the in-flight assault occurred, which was not the central district. We reject that contention. Under the relevant law, venue is proper in the landing district, here, the Central District of California. So the question was, where is venue? There are many different federal districts. Many states have more than one. So we have to figure out which federal district to have it in. And under the relevant law, according to the Ninth Circuit en banc, we can hear it in the district where the plane lands. That is a proper place of venue to hear this case. The Constitution safeguards a criminal defendant's right in two places. The venue clause of Article 3, Section 2 provides, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial should be held in the state where said crimes shall have been committed. The Sixth Amendment's vicinage clause further requires the defendant be tried by an impartial jury of the state and district wherein the crime shall have been committed. Under the two provisions, criminal trials generally must take place in the same state and district where the crime took place. But if the crime was not committed within any state, the Constitution provides the trial shall be at such place or places as Congress may by law direct. So if it happens within a state, then you have to have the trial there. If it doesn't occur within a state, international borders or international seas or other situations, then any place Congress by law directs will be fine. In Lozoya's view, the Constitution requires trial in the district which the plane was following at the exact moment of the assault. Her crime was committed in the airspace above a district, the argument goes, so that district was the location of her crime. Implicit in the reasoning is an interpretation of Article 3 and the Sixth Amendment that a state or district includes the airspace above it for constitutional venue purposes. So it says, this airspace above the state is part of the state, and therefore it can only be heard by that state. And Lozoya was not tried in whatever flyover district this might have occurred in, but rather the Central District of California, where the plane landed and where she lived and worked, because she was, after all, returning home. We disagree. Neither Article 3 nor the Sixth Amendment states that a state or district includes airspace. And there's, of course, no intention the framers intended as such. So, the idea of the airspace being within the boundaries of any particular state was not a concept that the founders were thinking about when they wrote the Constitution. That's probably very fair. For crimes committed on planes in flight, therefore, the Constitution does not limit venue to the district directly below the airspace where the crime may have been committed. And thus venue shall be at such place or places as Congress may by law direct. So the airspace doesn't have to be part of any particular state, especially when we're talking about these kinds of distances under the control of the FAA. And so since it's not within any state, even though you're over a state, it's not within the state, for these purposes, these provisions of the Constitution do not apply. So that makes sense. The relevant law contains two paragraphs, each covering a different kind of offense. First, any offense against the United States begun in one district and completed in another, or committed in more than one district, may be inquired of and prosecuted in any district where the offense was begun, continued, or completed. So if it occurs in multiple districts, then any one of them will do, because you have committed the crime in multiple different districts, and this is fairly typical too. And incidentally, as it applies to states, it would mean that every state would potentially have jurisdiction over you simultaneously. And it also wouldn't offend double jeopardy because they're all separate sovereigns. So, you could be facing multiple different charges from lots of different states at the same time because they all have a piece of you for the crime that you committed in their state. And the normal rule is that any part of the crime, as long as the crime is completed in the sense of meeting every element of the statute in any place, as long as a element of the statute occurred in the place, then they get jurisdiction. So you have to meet every element of the statute, but you don't have to meet every element of the statute here. You only have to meet one element of the statute. As long as you've made element of the statute somewhere, they have jurisdiction over you here, they have jurisdiction over you there, here, there, everywhere. It doesn't pay to commit crimes when passing state lines. Second, any offense involving in transportation in interstate or foreign commerce is a continuing offense. So then Congress goes around and says, okay, if it occurs in air travel, it is definitionally a continuing offense. And except as otherwise provided by enactment of Congress, may be inquired of and prosecuted in any district from, through, or into such commerce moves. So again, same kind of thing. It's like, for the purposes of this exercise, we're going to say that any district you moved in is good. Any of them will be fine. All of them are fine. So the government gets to pick its poison. Any of them would be fine. And this is, of course, a valid choice. Two of our sister circuits, the 10th and 11th circuits, have held the second paragraph of the law applies to in-flight crimes because the crimes took place on a form of transportation in interstate commerce. In both these cases, the court upheld venue in a district where the airplane landed rather than requiring the government to show exactly which federal district was beneath the plane when the defendant committed the crimes. We join the 10th and 11th Circuits and conclude the second paragraph of the law applies to federal crimes committed on commercial aircraft within the special aircraft jurisdiction of the United States. Lozoya's crime involved transportation in interstate commerce under the plain meaning of the word involve. A plane was involved, that's fair, but for interstate transportation, Lozoya could not have committed this particular crime. Yeah, if planes did not exist, she wouldn't have been able to commit the assault. So it is a necessary factor. The plane is a but-for thing in this equation, yes. An offense whose very definition requires interstate transportation certainly involves the transportation of interstate commerce. Fair enough. Our holding is consistent not only with the 10th and 11th Circuit decisions, but also with the near-universal practice of landing district prosecution. For decades, and since Congress federalized certain offenses committed in the air, federal offenders have been prosecuted and tried in landing districts. Venue in the landing district is plainly sensible. It is where arrests are made and witnesses are interviewed, and it is often the defendant's residence or travel destination. In our research, we found examples of landing district venue in every circuit except for the D.C. Circuit because there are no commercial airports in the District of Columbia. Reagan Airport is, in fact, in Virginia. So even though it's called National Airport, even though it has the tag of DCA, it is not in D.C. It is in Virginia. I've been there. A flyover venue rule would be unreasonably burdensome of the flight of the victims of in-flight crimes and interests of justice. Of particular concerns are victims of unwanted prurient touching. According to the FBI, reports of this on commercial flights are at an all-time high. Apparently, there is a lot of groping in the unfriendly skies. These assaults are most common on long-haul flights where the victim is sleeping and covered by a blanket or jacket. Sometimes there are no witnesses. Victims report waking up disoriented and realizing in horror that they were assaulted by a seatmate. Providing a precise time of assault could be impossible, and flyover venue rule could be no prosecution at all. So, yeah, the United States has solved this problem. As long as it went through the United States at any point, the United States has jurisdiction. Again, other places may also have jurisdiction. So your legal exposure continues to grow, right? So if you land in the United States, took off from the United States, or passed through our airspace, we got you. And maybe other people got you too. So, other countries you flew through. So maybe don't commit the assault on the planes so that every country in the world doesn't want a piece of you. That might be a good thing. We hold under the relevant law, venue for in-flight federal crimes is proper in the landing district. We adopt here a venue rule that is tethered to our Constitution, comports with the decisions of our sister circuits, and is consistent with common sense and the interests of justice. Thus, that brings us to the end of our discussion of United States of America versus Monique A. Lozoya. In this case, Monique was having a dispute with her fellow air traveler over the touching of the iPad that was built into the seat. As she was trying to get some sleep, and he was playing with the thing, and she said, "Please stop." Now, how she said this exactly isn't recorded. But what we do know is that an argument ensued, and then she hit him. And then he reported him to the FBI, and she got charged and convicted and had to pay $750. And she doesn't want to pay the $750 and argues, well, you had to try me the place where the crime occurred. And the Ninth Circuit Court of Appeals says, no, actually, because this occurred in airspace that's maintained and operated by the United States federal government, this is special aircraft jurisdiction, they can try you in any place the plane went through. Where it took off, where it landed, anywhere in between would be fine. So the landing point is as logical a place as any. That's where they picked. That's where they convicted you. Pay your $750. Maybe don't do the assault next time. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.